I'm now very pleased to turn over the microphone to Brian Schnurr, who will be opening up today. Please join me in welcoming him. Thank you.
Thanks, Paul, and good morning, everybody. So yesterday, we spent the day talking about planning the estate, and today we rip the sucker apart and we litigate the estate. And we have a range of topics that you will see that casts across the field of estate litigation, mental incapacity and mental incapacity litigation, dispute resolution, passings of accounts and executors' comp, and things like this. We have attempted to have the presentations done in different ways. Some will be the usual sort of lecture format. Others will be in the context of a panel discussion preceded by a short introductory lecture, and then others, such as Mr. Hull's, will be a briefer lecture but focused on a particular aspect of this broad topic of estate trust and mental incompetency litigation. Now, just a note with respect to questions. We have set aside, you'll see, 2 periods of time for questions, but it's never enough time. And what I would ask you to do, as I've asked people to do in other programs, other years, is feel free, of course, to ask questions during that time. We'll certainly take questions from the audience. But as well, it would be helpful if you would write out questions and drop them up to the front to me or anybody else up here anytime. And if you would put your name and phone number on the question, because what that'll do is ensure that at one point in the next week you'll get an answer, at least an attempt at an answer. Because if we don't get a chance to get to the question today, either I or, if it's a hard question, somebody else on the faculty will call you next week and give you the best attempt at a response. But we can only do that if you put your name and phone number on the question, please. Paul mentioned the evaluations. From my point of view, the important thing with respect to the evaluation is to please indicate, if you would, areas that we haven't covered, or in your view we haven't covered adequately this day that you think should be covered, because as you know, it's anticipated, this being the 2nd annual Estates and Trust Forum, that there will be a 3rd, 4th, annual Estate and Trust Forum. So let us know of topics that you think aren't covered or aren't covered properly. And furthermore, the other thing that's helpful, certainly to me, is to give us an idea whether you think that the content of the materials and the content of the oral presentations is at an appropriate level. It's always difficult to know whether one should be dealing more with fundamentals, more with advanced stuff, this type of thing. So that kind of comment is also extremely helpful in terms of organizing this for future years. Now, I have the great pleasure to introduce the first speaker, and while I'm tempted to go into all his superb qualities and accomplishments, I don't think I will at this point, since it's me. So I think instead I will just start in with my topic, which relates specifically to challenges to wills. And rather than go over sort of the usual ground about challenges to the wills, what I've attempted to do is select topics that haven't been dealt with before, or at least haven't been dealt with exhaustively, and to look at them in some cases from the point of view of the propounder of the will, and some cases from the perspective of the challenger to the will. And I'm not going to be covering everything, and nor would you want me to cover everything that I've got in the paper that's in your materials. I just point out to you, if you look at the table of contents, that I have at number 2 there, summary of will challenge procedure. I've made it a summary. That information, again, is information that's covered often in these kinds of programs, so I didn't feel it necessary to go into it in detail, and I'm not going to speak about it this morning, but it's there if you want a reasonable summary of the procedure itself. The other topics, a number of those, onus of proof, obtaining hospital records, etc., I am going to comment on this morning. Just a word about the appendices. Appendices 1 through 5 are, in essence, precedents, procedural precedents. And they're there if you need them. If they're helpful, great. 6 and 7 are also procedural precedents, but they're specifically 2 types of the order giving directions in will challenge procedures. 8 is a request to admit. This is a procedure and a document that I'll speak about in a few minutes, and I just have a precedent of that in the materials. 9 is another order giving directions, and this one I've included. It's not bang on with the topic that I'm covering, but just so you have, now that we are in our mandatory mediation process, as you know, as of September 1st, 99, virtually every bit of a state litigation commenced after that time must go through mediation. I've included an order giving directions that consolidates both the substantive matters that are generally in an order giving directions in a contested will process, and also the mediation matters that have to be addressed, and there's no reason why they cannot both be dealt with in one order rather than having 2 separate orders. And Appendix 10, I'm grateful to Jasmine Sweetman at the Miller-Thompson firm for allowing me to include as an appendix an article that she's about to publish on the question of costs. I've dealt briefly with costs in my paper, and I'll talk about it a little bit this morning, but Ms. Sweetman has gone into it very thoroughly in a very up-to-date paper, and that is Appendix 10. So that's the material that you have. Let me get into my remarks. First of all, let me deal with matters of sort of the first interview or the first contact with the potential challenger to the will. And the scenario that I'm dealing with here is one that I face very frequently, and a number of you would as well, and that is when the person comes into your office having placed a telephone call and feels strongly, they think, about challenging the validity of dad's, grandma's, sister's, whatever's will. And I suggest at that interview, at that first contact, that there are 3 matters that must be discussed in some detail with that client. There are others, but I'm suggesting that there are 3 that must be discussed. One is to make clear the grounds for challenging a will. Secondly, the responsibility for costs in will contestation matters. And thirdly, who has the onus of proof. And dealing with them in that order, the grounds for challenging a will. I think the first thing that one has to emphasize to the client, and sometimes it takes a significant period of time, is that there is no ground to challenge a will on the basis of unfairness. The client so often, of course, will, and justifiably in terms of where they're coming from emotionally, be telling you how unfair this will is and how it's not right and how father intended to change the will because son and father were reconciled 3 years ago and this will predates that reconciliation and all that kind of thing. And what we must emphasize to the clients, of course, is that to contest a will, there are certain legal grounds for challenging the will. The testator can be as eccentric, as mean, as perverse, as bitter, as unfair as he or she chooses. The question is, of course, did the testator have capacity? Was the testator unduly influenced? And then more wild and wonderful things in terms of fraud and forgery, which I comment on to some extent in the paper. So I certainly recommend at that first meeting that you get into a very clear discussion with the client as to what must be shown before a will is set aside, and stress the fact that a court does not lightly set aside the chronologically last will of the testator. The usual grounds, again, testamentary capacity, presence of undue influence, lack of knowledge and approval. When you're discussing undue influence with the client, I think here again it is awfully important to stress to the client, because the client will only hear influence. The client won't hear that adjective undue. And it's important to stress to the client that while there might be something morally wrong with influencing father and saying to dad, hey, I've been the best of the 3 kids, you should leave everything to me, there's nothing legally wrong with it. And that undue influence requires some kind of coercion, some kind of figurative, if not literal, arm twisting. And as you know, if you look at the body of case law dealing with contestation of wills, you don't find too many cases, there are certainly some, but you don't find too many cases where a will has been set aside solely on the grounds of undue influence. It's a very difficult thing to prove, and as I'll comment in a moment, the onus, of course, is on the challenger to prove it. And it should be of no surprise to any of us that usually those people who will unduly influence a testator don't leave a lot of evidence of the fact. They don't usually leave a memo about the fact that they've unduly influenced, very seldom any kind of videotape, so there isn't exactly a hot trail to follow. So it's a difficult thing to prove, and that's where a discussion about suspicions and what they count for in a court of law and evidence is very much warranted. Knowledge and approval has become, and suspicious circumstances, another way of saying the same thing, has become a very important aspect of challenging wills today, because while the notion of the fact that the testator must have knowledge of and approve of the contents of the will has been around for eons, there's been more attention paid to it of late, especially since Woutton Hay, the Supreme Court of Canada decision that I allude to in the material. And knowledge and approval is certainly a far more fruitful ground where you have suspicious circumstances. That is, where there's a major change in the will, where there has been, where there is health problems with respect to the individual, where there are circumstances that made the testator vulnerable to influence, where you don't have enough to prove undue influence. Certainly the emphasis instead can be placed on this question of knowledge and approval and suspicious circumstances, and Woutton Hay sets out quite clearly the responsibility that lies on those propounding the will where there are suspicious circumstances. And the important thing is that in those, in that challenge, it is the propounder who has the onus of proof, not the challenger. Now, second thing that you gotta talk to this challenger about at the first interview is the question of the costs. It's of particular importance to the challenger. It has to be, whether the challenger thinks it's important or not. There's been a lot written about costs in will contestations over the last little while, and again, I commend Ms. Sweetman's paper as being the latest that I know of that's been written about it, and a thorough treatment of the subject. There's a lot that's been written about it in terms of whether there's been a trend in the past to costs out of the estate, a presumption that costs will be paid out of the estate, whatever. I'm not going to go into that today. It's to some extent addressed in my paper, better yet addressed in Ms. Sweetman's paper. It is true that there are circumstances where things smell so bad in terms of suspicious circumstances that even if the challenger goes forward and loses, that the court will grant the challenger's costs, party and party, sometimes solicitor and client, out of the estate. But those circumstances certainly are, if they haven't been in the past, they are now the minority of circumstances, or becoming the minority of circumstances. That is that generally now you have to advise the challenger or potential challenger in your office that for the most part in litigation, generally in litigation, the costs follow the result. And that in estate litigation, while there are some exceptions to that, for the most part, the likelihood, again, in will challenges is going to be that the costs follow the result. Now, it's time-consuming litigation, any of you that have been involved with it, and consequently the costs can be absolutely enormous. And therefore, that challenger, I don't care how badly the circumstances may reek in terms of it being suspicious and the rest of it, that challenger has to be made aware of the fact that he or she is not going into this piece of litigation with impunity because he's heard that costs will be paid out of the estate. And time again, it doesn't matter how often one discusses this aspect of costs, this is what the challenger is either being told or being led to believe. When deciding the responsibility for costs, the main 4 factors that you'll find from the case law that the courts are looking at in decreasing order of importance are these. First of all, the merits of the challenge. The first thing the court's going to look at, I'm now positing a situation where you've taken it to trial, you're representing the challenger, you've lost. And now the court has set aside a time another day to argue costs. And I was in court yesterday, which is why I wasn't here, and a matter before and after me, because it continued, was just that yesterday. Just the argument about costs where a will had been challenged and challenged unsuccessfully. So the court looks at the merit of the challenge. How much justification is there, the judge asks, for this challenger going ahead and taking this matter to trial? And here you'll see recent cases, I refer to some, Ms. Sweetman refers to others, it's where the court distinguishes between how badly the case smelled at the outset and what the aroma was as you got past discoveries. So if you get a lot of answers through the discoveries and through the hospital records and the doctor's reports and the rest of it, the court's going to look at that and make that decision about whether you should have stopped the case then. And there are decisions where the court has awarded the unsuccessful challenger costs to the discoveries or to the point of getting expert reports, and then either denied the challenger costs thereafter or going further, holding the challenger responsible for the propounder's costs. So merits of the challenge itself are the most important consideration. Secondly, efforts to settle. as I'll comment on in a couple of minutes, we know that estate matters, estate litigation, is not bound by the mandatory cost consequences of flowing from Rule 49 formal offers. That's been established. Sheard and Rewrite and other cases have established that. However, it's also been established that before we ever had Rule 49, of course, offers to settle were extremely important with respect to the matter of costs, and therefore the court's going to carefully look at, in your challenge to the will, what kind of offers have been made, and if you're the challenger and there's been some kind of offer made to you, and don't forget in these cases, unlike a lot of other litigation in challenges to the will, there's no middle ground. You can settle the case, but the judge has no middle ground. The will is valid, the will is invalid. It's an all or nothing proposition. And so if you as the challenger are offered some settlement, be it reasonable or be it damn low and just nuisance value, and you reject it, and then you end up losing and getting nothing, that is going to be a very heavy argument, a very difficult argument for you to meet in terms of the propounder saying that you should be bearing your own costs and bearing some of the propounder's costs. Third factor is size of the estate. You'll generally find, of course, that the lower the value of the estate, the more modest is the estate, the more carefully the court is going to, and critically, the court is going to scrutinize a pitch for the costs of the challenger in an unsuccessful challenge out of the estate, simply because the court doesn't, and it makes a lot of sense, doesn't want to see the beneficiaries who are successful, in fact, paying for the challenge that was made against them. Of course, that is not to say that if you have a larger estate, again, costs are going to be ordered out of the estate. I'm not saying that. I just am saying that the factor of the size of the estate is one that very much comes into this determination of who's going to end up paying the costs. And finally, there is the issue of how forthcoming the propounder was with information. You'll see some of the decisions with costs where the court has been sympathetic to the challenger's pitch for costs by virtue of the fact that the propounder decided to play it very close to the vest and wouldn't give information and wouldn't allow the solicitor who drafted the will to be interviewed and all this kind of thing. And it, from my perspective, looking at it on the other side of the fence, from the propounder's point of view, the message is that if you've got a solid case supporting the will, don't be reluctant to share that evidence right at the outset with the challenger, because nothing is more influential with the court at the end of the day than you pointing out, here's a letter I wrote right after we got the notice of objection, telling them they can meet with the lawyer, they can see the family doctor, will consent to that, there is no evidence supporting their challenge, etc., etc. Moving on to the last area that I suggest is important to go over with the challenger or potential challenger at your first meeting, and that's onus of proof. This area of challenging wills has a lot of, or these cases involving challenges of wills, has a lot of fascinating aspects to it, and one is the fascinating aspect that depending upon what the ground is, one or the other of the challenger or propounder has the burden of proof. So when it comes to due execution, testamentary capacity, knowledge, and approval, it's the propounder who at the end of the day has to convince the court on the balance of probabilities that the person has testamentary capacity, will was duly executed, person had knowledge of and approved of the contents of the will. Undue influence, as I mentioned before, fraud, if those allegations are being made, then it's the challenger's onus at the end of the day to satisfy the court. And you have to be somewhat careful procedurally that if the directions order I've got in my precedents two directions, or I've got the one involving mediation as well, but the two that just deal with substantive aspects, I've got one that directs there to be pleadings delivered, and one that is more consistent with the style that's been adopted for decades and decades and decades, which is that the issues to be tried are the following, the parties are to be the following, etc. And if it's that second order that you use, second approach, where you don't have pleadings, be sure you work out well ahead of trial who the heck is the plaintiff, because it can get a little confusing, and I've seen it at trial where counsel are ready, well, sort of ready, to join issue at the trial, but have different views as to who's leading the evidence first, because there's a challenge based on testamentary capacity, undue influence, knowledge, and approval, and due execution typically. And one says, no, he's got to lead the evidence first, the other one's got to lead the evidence first. So if that's not clear between counsel, then you're going to have to bring a motion to the court to determine just who is leading evidence first. Generally, in a will challenge case, it doesn't matter how many challenges are there, and whether or not undue influence is alleged, and therefore there's something that the challenger has the onus of proof in relation to. Generally, it is the propounder who opens the trial and presents his or her evidence first. Now, the next topic I want to comment on is, again, from the challenger's perspective, and this is the pretrial examination of non-parties. Usually it's witnesses to the will who we're trying to examine ahead of time. Sometimes it's doctors. Sometimes it's others. But the important thing is to note the importance of Rule 3110 in this area of the law, because I'd go so far as to say that there shouldn't be any case where somebody is challenging a will and you should be going to trial without having examined for discovery the witnesses to the will. I'm not talking about an informal examination. I'm talking about examining pre-trial the witnesses under oath with a transcript so that you have that available at trial. Many courts have confirmed the obvious, which is that the most important evidence in almost every, not every, but almost every will challenge case is the evidence of the witnesses to the will. Not too difficult to figure out, since they are the ones, the witnesses and the draftsperson, and often one of the witnesses is the draftsperson, the lawyer. Not a difficult thing to understand, since these are the people who were there at the crucial times of instructions being given and execution of the will. And therefore, these people, the evidence being so crucial to the case, you should not, as a challenger, ever have yourself in the position where you are going forward not having examined those witnesses, or at least one of them, but I maintain both, under oath ahead of time. And if you look at Rule 3110, which of course doesn't relate in any way specifically to this area of the law, it just talks about the examination of non-parties, there are 5 criteria that must be met before a court will give you an order to examine non-parties. Sometimes it'll be done on consent with the other counsel, but if you need an order under 3110, you have to satisfy these 5 criteria. You have to be able to demonstrate that you were unable to obtain the information that you're seeking from the parties to the litigation. Remember, we're talking about examining non-parties. Well, this one should be easy to satisfy, because typically the only people who were present at the time the will was signed and instructions were given are the witnesses, the draftsperson to the will. So you can't get information about what happened at that crucial time from anybody except the witnesses. Second, you have to show that it would be unfair to require you to proceed to trial without the examination. Once again, based on the pitch I just made, I don't think you should have difficulty with that. Then the next three are that it won't delay the commencement of the trial, not unreasonably expensive, and not unfair to the person sought to be examined. Now, just note that if you go ahead and you examine the witness to the will, and you therefore have that transcript of the examination, which is very important for you at trial, you will note that by sub-rule 5 of 3110, you cannot read that evidence in at trial. You can't read it in. You cannot read it in the way you can read in to your case the evidence of the examination for discovery of the adverse party. But importantly, what you can do is you can use that evidence on cross-examination of the witness to impugn that person's credibility, which is absolutely crucial. So it's very important evidence. I also point out to you that often we try to get this order made in the order giving directions right at the outset. Now, technically, it could be said that the court shouldn't be making an order for the examination of non-parties at the order giving directions. That is, we try to get an order at that point saying that the solicitor who drafted and is a witness to the will and his secretary will be examined as a non-party. While we try to get that, and often do get it, there's a technical argument that it shouldn't be made at that point because, as I just said, one of the 5 criteria set out in the rule are that you have to demonstrate that you couldn't get that evidence from any other witness. So usually you are to go through your usual examination for discovery before you can get your order under 3110. However, if you look at Rule 2 of the rules, which kind of allows the courts to fudge the rules a bit in the interests of justice, it seems to me that there's a strong argument and logic to say that my examination of the adverse party is clearly not going to give me any evidence as to what happened at the time the will was signed. And therefore, Judge, you might as well make that order now. There's no reason not to. So that's 3110. A quick comment or two with respect to hospital records. You know full well that hospitals and doctors won't release their records, shouldn't release their records without court order. Now, generally, therefore, we try to get an order in the order giving directions as part of that, that will give us access to the hospital records and any medical reports, any physician's notes, what have you. And there are generally 2 approaches that I see taken. One is that if you're having an estate trustee during litigation appointed, what we used to call an administrator pendente lite, then you have an order within the order giving directions saying that that estate trustee during litigation is given the authority by the court to demand any hospital medical records that any of the parties direct him as the estate trustee during litigation to seek, and the hospital and doctors are hereby ordered to turn them over to the estate trustee during litigation, who then disseminates them to the parties. The second approach is to have an order indicating that any hospital records, medical records demanded by any of the parties in writing with a copy of this order are to be released to the party, and then within a certain number of days are to be distributed to the other parties. I prefer the second as opposed to the first, just because I don't like to have an estate trustee during litigation who's not even a party to the proceedings being the one who's supposed to be responsible for getting the medical records and all of this. I've given at page 5 in the materials, I've offered a precedent of this type of order, which I hope and I believe satisfies the concerns I have about it not being too broad but at the same time not being too restrictive. You've got to be very careful. You don't want to refer to doctors' records, physicians' records. You sometimes have to be careful even referring to health care providers, because you want social workers who, in my view, would qualify certainly as health care providers, but it's hard to know. And sometimes the nurses' records, oftentimes the nurses' records are far more valuable than the doctor's records. So I have a precedent in there which hopefully may be useful to you at some point. Next comment relates to an approach or a technique that can be helpful to the propounder in these proceedings, and this is the request to admit, and this is Rule 51. And this is used a lot in general litigation. It's not used very much, at least in my experience, in estate litigation. And the structure of the rule is very simple, that you serve a request, you as a party serve a request on the other party that the other party admit the truth of certain facts, and you itemize the facts, whatever number of facts you wish, and you also, or you can also, request that they accept the authenticity of certain documents. The other party, by the rules, has 20 days to respond to that, and there's a form 51B that the other party must serve on you, indicating which facts, which documents they accept, which they don't, and if there's no response within 20 days, then the other party is deemed to admit the facts and the authenticity of the documents that have been listed. And it also says in the rule specifically that if the other side refuses to admit certain facts or admit the authenticity of certain documents, and those documents or those facts are proved authentic and accurate at trial, then that is something that the court may take into account when deciding costs, on the disposition of costs at the end of the trial. Now, I say that this is particularly useful to the propounder because as the one who generally is responsible for opening the case, and usually starting with the witnesses to the will and having the onus to prove due execution and testamentary capacity and knowledge and approval, it can be very helpful to set out in a request to admit the details of the execution process, the facts relevant to testamentary capacity, and even in response to undue influence in your particular case, and documents that have been signed by the testator around the same time or previous wills. These can all be included within the request to admit, and what it can mean is that you as the propounder just have that much sort of lighter a load to carry into the court in terms of what you have to prove in your case. And as I mentioned before, in Appendix 8, I've got a copy of the precedent of the request to admit. I think last comment that I'm going to make, because I don't want to establish a bad precedent of going overtime. Oh, I've got some time left. I'm okay. All right. Expert witnesses and opinion evidence. Very important in will challenges. The most common experts, it won't surprise you to know, of course, are the physicians and forensic document examiners. Expert witnesses, opinion evidence, for the most part governed by Rule 53.03 and the Evidence Act, Section 52. Just 4 points with respect to the use of experts. One is, as counsel, vitally important that we give clear facts to the expert, clear facts in relation to which we are asking him or her to express an opinion. Sounds axiomatic, but assume that your letter to the expert is going to be produced at trial, and therefore make sure, obviously as counsel, you aren't doing anything to direct the expert's opinion, and be sure about the facts that you're asking the expert to assume in formulating the opinion. Second, remember that the expert, of course, must produce a report, and with the rule change a little while ago, the report now must be served at least 90 days before trial. And it's important that the report be thorough, and especially if you're dealing with an expert who hasn't offered testimony to a court before, you've got to provide the assistance to the expert and make sure it's relatively thorough, because if you have a very sketchy report, you may well find objection at trial and the objection upheld to your expert testifying orally with a lot of detail that isn't in the report and could have been in the report. Third point is, remember, of course, your expert has to be qualified before the court, qualified as an expert in that field. And there's lots written about how to qualify experts. I'm not going to get into that. The only thing I suggest is, as an aid, when you have your expert qualified, have written out for yourself very clearly, word for word, how you're asking this expert to be qualified, so that when you read it into the record and the reporter takes it down, there's no question as to the expertise, the area of expertise that's been accepted by the court of that particular expert. Because, as you know, oftentimes you get into issues of whether the testimony the expert's now getting into really falls within his or her expertise or it doesn't. So you have to make sure that you've got that expert qualified as you want him or her qualified, and I don't think that's something you want to leave up to you formulating the words at the time. Have it written out and read it to the judge when you're getting that expert qualified. And fourth, and perhaps most important, and that is that be sure that you make it clear to your expert what his or her role is. The expert before a court, as you know, is being given license that a witness generally doesn't have. That is to express his or her opinion about matters, about certain facts, based on his or her expertise. Because that license, that authority is being given to the expert is looked upon very much as the court's witness. The expert is not supposed to be an advocate. And I've made reference in the materials to the relatively recent case, I think it was decided maybe 2 years ago, whatever, Calvert. Take a look at Calvert if you want to see a court reacting to not one but two experts, both psychiatrists, in a matrimonial case, and it relates to our area in the sense that the issue was whether the individual, I don't remember all the particulars, but whether the individual had the mental capacity to marry or to divorce, I can't recall which. And expert evidence was called, and the judge reacts strenuously to what she regarded as really advocacy on the part of the experts, as opposed to a strong degree of dispassionate objectivity on the part of the experts. So I find that this is a much more difficult task the more experienced the expert is. The experts can get very arrogant, and that arrogance can translate into very strong beliefs and a lack of willingness to agree to the possibility of any other view prevailing, and that's not the image that you want to be conveyed to the court with respect to your experts. Just a special word with respect to forensic document examiners, because in our line of practice and will challenges, when you deal with due execution and sometimes forgery issues, forensic document examiners become very important as experts. And this is a somewhat unusual class of expert, because there isn't any governing or regulatory body with respect to forensic document examiners. And as a consequence, there isn't any specific training or educational requirements to be able to call yourself a handwriting expert or forensic document examiner. And you have to be very careful, because there are people in this field, for example, who call themselves graphologists. And what graphologists, at least the ones I've met, are really involved with is that they examine handwriting, and from that will give an opinion as to the individual's personality traits from their handwriting. This is not forensic document examination, and the last thing you want to do is have your expert up there and then be presented with a background where this person has, for some newspaper, and there have been a number of these over the last decade, commented upon some figure of some notoriety based upon his or her handwriting. So be careful when you're relying upon forensic document examiners. And last few just quick comments on some things that aren't in the paper, but just a sort of a hodgepodge of comments. Security for costs. In will challenges, if the will is being challenged by somebody else, you won't find this in the paper. I just had some additional thoughts when I was going over this last night. That if the will is being challenged by somebody outside of the jurisdiction, look at the rule with respect to security for costs. There are precedents, there are cases, recent cases, where the court has ordered security for costs and significant amounts for security for costs. There are also cases where the court has denied it and said that the court doesn't consider it appropriate in will challenge circumstances. But what I'm saying to you is, if you are representing the propounder of the will and your challenger is outside of the jurisdiction, and you're looking at, particularly if you're looking at a relatively modest estate and consequently potential for disproportionately large costs in the matter, consider a motion for security for costs. Second point is, judges feel differently about the necessity of the executor under the will that's being challenged being a party to the proceedings. That is, if I'm the executor under the last will and it's being challenged, should I be a party to the proceedings on the basis that, of course, my fundamental obligation is to support, propound, bring forward that will. So I should be the one fighting the challenge. Now, that's true, and there are some instances when indeed the executor of the will turns out to be the person propounding the will. However, in most cases, it's the beneficiaries, those with a financial interest under that last will of which I'm the executor, who will be taking up the good fight. And therefore, there's no reason for me as the executor either to retain my own lawyer and just increase the costs in the fight, or to join in directly and be represented by the same lawyer who's representing the beneficiaries. Instead, I suggest in most of those circumstances the best approach for the executor to take is to submit his rights to the court so that the executor is bound by the order. The executor is before the court, as many of the judges insist the executor of the impugned will must be, but not actively in the fray. Next point is, I mentioned Rule 49 earlier, and again, whether it's, and this is not restricted to my particular topic this morning, contested wills, but also with respect to dependent support claims, disputed compensation claims. Don't underestimate the importance of an offer to settle. It doesn't have to be a Rule 49 offer, but in compensation cases, for example, many times I will put in an offer to settle whether I'm representing the executor or whether I'm representing the beneficiaries. And this can have a very strong effect upon what the result with respect to costs is going to be at the end of the day. And I think with that, I will end my comments, and I will move effortlessly into an introduction of our next speaker, Rod Hull. It's always a pleasure for me to introduce the man who I consider to be the dean of the bar of estate litigation. Rodney's a wonderful example of a lawyer who makes sure that he keeps his life interesting and balanced with many interests outside of the law. He's a landscape painter. He's a bagpiper, a horrible one, but he's a bagpiper. He's a snowmobiler, a dangerous one, but he's a snowmobiler. Just to name a few of Rodney's interests. And Rodney's dedication over the years to continuing education with respect to particularly this area of the law, but not confined to this area of the law, is in my view unparalleled. And as further evidence of that, Rodney is gracious enough to spend some time with us today on a special day to him. This is Rodney Hull's birthday. And I knew it was Rod's birthday. I didn't know how old you were. So I contacted one of your friends who's no longer in the practice of law. He's on the bench to find out how old. I contacted him yesterday to find out how old Rodney Hull is. The response I got was, "Rodney Hull, is he still alive?" So I still don't know how old Rodney is, but I do know he's still alive, and he's going to assist us today with some thoughts on summary judgment motions in estate disputes. Rodney Hull.
Thank you, Brian, very much for doing what my wife didn't do this morning, and that's remember my birthday. I'm delighted to be here again, and I was looking through the papers yesterday, and some of them are very scholarly dissertations on estate planning practices and taxation and how you should leave your will. I'm reminded of a former colleague of mine who used to lecture extensively on estate planning, and rather than all the technical stuff that you find in the text, I remember one of the things he used to say was, "Always leave $1,000 to Greenpeace, you may come back a whale." As to my age, when I leave this lecture platform, I'm going out to my insurance company to buy a riff, so you might have some kind of an idea what I am. It's not so bad as you grow older. I find there's a lot of things to look forward to, and I'm looking forward to Easter next year when I can hide my own Easter eggs. Now, you got to have a little bit of fun in this business. Talk about summary judgment. We go from a high point to a low point. I have 15 minutes to go into the subject. I have divided my paper, first of all, into my notes. Schedule A is the rules. Schedule B is the case decided by Mr. Justice Hoylett, and Schedule C is the judgment of the Court of Appeal, which consists of 5 lines, and I believe was written on the back of a cigarette box. The rule basically is that it's set out best on page 7 of Mr. Justice Hoylett's decision, where he refers to the Court of Appeals judgment as in the numbered company case, when it said the rule is clear the rule is intended to remove from the trial system, through the vehicle of summary judgment proceedings, those matters in which there is no genuine issue for trial. The motions judge hearing a motion for summary judgment is required to take a hard look at the evidence in determining whether there is or is not a genuine issue for trial. The onus of establishing that there is no triable issue is on the moving party. However, a respondent on a motion for summary judgment must lead trump or risk losing. Now, prior to the promulgation of these rules, there was an old rule called a specially endorsed writ rule, where you could get summary judgment in certain cases where there was specified amounts of money or interest involved, and it went no further than that. Then the rules were then passed, much wider scope, intended, I think, mostly for the general litigation bar. But in this case, in the case of Strauss versus Bainbridge, it's been extended to estate matters. And so it is when there is a contested will, for example, and there is no merit to that contested will, and it can be demonstrated to the judge at an early stage that there is no such merit, then it would be appropriate to bring a motion for summary judgment. Basically, there's a motion brought, there's an affidavit, there's cross-examinations, and there's a factum filed, and it goes before the court. And if the court sees that there is no case to challenge the will, then then probate will be granted. Now, once again, if you are challenging the will, you better put your best foot forward as set out in the Court of Appeal decision. You better lead trump or risk losing your case. It's interesting, though, to deal with the case of Mr. Justice Hoylett, called Strauss and Bainbridge. And the facts of Strauss and Bainbridge are pretty simple. Mr. Bainbridge and Mrs. Bainbridge #1 were married, had one child 2 years of age, and one child was in gestation when they were divorced or separated, and Mr. Bainbridge went his way and Mrs. Bainbridge #1 went her way, and subsequently she married a gentleman by the name of Neagle. Mr. Bainbridge married again Mrs. Bainbridge #2. Now, Mrs. Bainbridge #2 died before Mr. Bainbridge, and Mr. Bainbridge, at the time of his wife's last illness, was assisted in great measure by the Strauss family, who helped him care for his wife, and bonds of very strong affection were made between the Strauss family and Mr. Bainbridge. Mr. Bainbridge left his estate to his friend, Mrs. Strauss. Now, in the meantime, of course, the children of the first marriage of Mr. Bainbridge were adopted by the husband, the second husband of Mrs. Bainbridge #1, and accordingly they were adopted by Mr. Neagle and became his children. And under the Child Welfare Act, as you all know, those children became, for all purposes, the children of Mr. Neagle. And the strange thing is that it was these children who challenged the will. Now, Mr. Bainbridge had never seen these children from the time he left the home until after, well, since he left the home. And pretty hard to see somebody after you die. Although I'm hopeful that you can. And in any event, these children, who really had no right whatsoever to challenge the will, challenged the will. And the judge, in his judgment, said they had no status to challenge the will. Nevertheless, the judge went on. He then found and quoted from the Court of Appeal and stated that the evidence before him, which consisted of an affidavit filed by one Christine Medland of Davies, Ward, and Beck, and which quoted notes and statements made by Mr. Cullity, as he then was, and they seem to indicate very clearly that there was no question of testamentary capacity, and when God is with you, who can be against you? The judge found on that basis that there was no lack of testamentary capacity, that Mr. Bainbridge knew exactly what he was doing. It may have been a cruel act to cut out his children, his biological children. But nevertheless, the judge said, well, as far as I'm concerned, testamentary capacity he had. Now, as far as undue influence is concerned, which was the second main concern put before Mr. Justice Hoylett, was that there was no evidence of any undue influence. And Mr. Justice Hoylett had some rather scathing comments to make about the affidavits made in support of the challenge to the will by the son who filed the affidavit. And I'll leave those words for your reading later on, but they're quite indicative of a judge that was a little bit upset with the situation. And under the circumstances, he said, well, I'm declaring for testamentary capacity. There's no real challenge to undue influence that I can see. That the onus is on them to prove undue influence, and so I'm permitting the will to stand. This matter was then brought before the Court of Appeal, and it was a judgment of the Court of Appeal. And once again, I don't understand how it got to the Court of Appeal, because as far as I can see, this is a proceeding under Rule 75, and the appeal should have gone to the divisional court, but nevertheless, the Court of Appeal decided the case. They, with what I consider to be some lack of candor, pole vaulted over the main issue that there was any jurisdiction to make the order. Because first of all, in order to commence the proceedings, you have to have a notice of objection. That notice of objection can only be filed by a person who has a financial interest in the outcome of the litigation. Now, neither of these two children had any financial interest. They had both been adopted by Mr. Neagle, and even if the will was upset, what would transpire would be that the will would go on an intestacy to the relatives of Mr. Bainbridge, and they were not relatives, and they did not share on an intestacy. So it's a mystery to me why the case ever got as far as it did, but it is a very helpful case for us, because I know of no area of law that is more badly abused than people who come forward and challenge wills. And notwithstanding what Brian says about costs, it frequently happens that costs are, in many cases, taken out of the estate when it may not be what you would think was a fair way to dispose of costs. But if it were otherwise, Brian Schnurr would not be the rich man that he is today. Now, I have to say, though, once again, remember, you always have to look and see if there is a prima facie case against you. And if you think there isn't, it is well worth your efforts to try and get your will through on the summary judgment basis. And to that extent, I think it's probably well said by the Court of Appeal when they say, if you're going to do this, then the person who is the respondent had better do his very best to make sure that he doesn't let judgment go at this preliminary stage of the proceedings, because, of course, then you've lost everything. And I see that it's about time for coffee, but I have to make one comment on Brian's statements with respect to forgery and document examiners. He and I once had a case involving a forgery, which I was putting forward, and it turned out to be a forgery, but that doesn't matter. At his suggestion that you stay away from graphologists who go into the character of the person who wrote the will, they're not bad people if you think you've got a forgery, because it's a good way to take the judge's mind off the issue. Having said that, I must say I'm glad to be back again, and I'll be around for a while yet. Thank you.
Thank you, Rodney. A delight as always. We'll break now, and we'll reconvene at 10:30, please.